But there's another plea, and it's called standing mute before the court. Now, when you stand mute, what you're saying is, I don't recognize the jurisdiction of this court. What we're in here is the patent court, and we're charging me with murder, and the patent court has no jurisdiction. Therefore, you've got to go to another court. We're going to enter a special appearance. We're not here voluntarily in an equity court. We're here against our will and over our objection, and the only reason that I'm standing here is because if I don't come in here, you're going to issue a warrant and some policeman's going to come out and throw me in jail. And to preclude that probability or possibility, I'm going to come in here and I'm going to challenge the jurisdiction, and I'm going to tell you plainly I'm not here voluntarily. Okay? They're standing mute. Now there's one last plea. Here's your fifth plea. Double jeopardy. Perhaps you've already been charged with this crime. It doesn't occur very often, and double jeopardy isn't very likely to be brought against you, because what that entails is that the jury has found you not guilty, or the court has found you not guilty and dismissed the case. Now, not dismissed before you went to trial, but dismissed after the jury verdict came in. And that can occur in a couple of ways. It isn't very likely that you'll enter a double jeopardy plea, but it isn't impossible, and you always want to be aware of that possibility. We'll talk about that in a little while, and I'll cover some possible angles on double jeopardy. All right, now going on here then, I again assert my demands to all of my rights under the Constitution of the United States and the substantive common law at all times, never waiving them. Boy, the first thing I do when I walk into that court, I want to demand all of my rights so that when this case goes to the Supreme Court, there's never any question about, well, let's see, does this man have rights? This man never waived his rights, and he said so over and over and over again. So whenever there's any minute question about, well, did he waive his right to counsel? Did he waive his right to time at this hearing? Did he waive his right to time at that hearing? Anytime the court or any prosecutor says, yes, he waived his right at this hearing, he waived that right there, he waived that right somewhere else, poppycock. That man never waived his rights at any time and said so time and again. Now let's take a look at understanding these charges. I'm saying I cannot understand the charges against me as I fail to find a stated cause of action which is against me. So therefore, I cannot understand how charges can be brought against a free and natural person under the common law, as I have specifically denied any and all jurisdiction of mercantile equity or executive chancery. I'm telling you plainly then, I don't have a driver's license. There is no contract. I haven't volunteered into this enterprise. I'm not a gun dealer. So therefore, you can't search my car looking for guns. You can't come into my business searching my gun records. I am not engaged in the gun business. There's no cause of action against me because this is entitled the State of Idaho plaintiff. And the State of Idaho is not the injured or damaged party in this alleged crime. I'm charged with a crime of omission. I don't have a driver's license. I don't have registration. I don't have proof of insurance. Well then, if I don't have these things, then it's because I've committed an act, if you could call it an act, of omission, which is a contradiction of terms. You either act or you don't act. If it's an omission, it's the opposite of an act. All right? So I don't understand the charges because we don't have any statement here as to what I've done. If I didn't get a driver's license, did somebody get a bloody nose? Did somebody go to the hospital? Did somebody lose some money? Who is the party of interest in this case? Well, you didn't pay your tax. You see, you didn't go down and buy this license, and therefore the people of the State of Idaho have been deprived of this $7. Well, now we come back to the question of, well, can the State of Idaho compel me to take a vacation to Hawaii? Can the state compel me to buy insurance? Can the state compel me to buy a license? I'm contending no. You can't compel me to buy a license. Where rights are involved, there can be no rulemaking or legislation which would abrogate them. So therefore, if there is a rights issue, the state legislature cannot compel me into a contract. So I'm driving on my right-of-way as a matter of right. Well, does it affect the public interest, you say? Well, that's for the government to prove that it affects a government or a public interest. How does it affect the public interest? How was the public damaged? How does this failure to buy a driver's license affect trade, commerce, business, and industry? And how does it affect it adversely? And what cause of action are you claiming against me? Now notice we've got a plea next. Since I cannot understand any charges bearing no cause of action, I cannot enter a plea to the court. Now, a cause of action is a statement. It's like a specific purpose statement in a speech. In a cause of action, civilly, I allege, and my affidavit in support of the allegations claim that you drove your tractor across my lawn and tore it up and cost me damages, cost me money of $150 to fill in the holes and to reseed my lawn. That's a cause of action. You have a contract with Sears or anybody, and you agreed to pay $50 a month on the washer and dryer for 12 months, but you only paid it for 10 months. Well, now what have you got? You've got a breach of contract, and Sears has a cause of action against you for that breach of contract. There's a cause of action. And then they present the cause of action to the court, and the court subpoenas or summonses you in, and they want to know, well, how do you plead to this? What explanation do you have? I've got Sam Jones over here, and he says you tore up his lawn with a tractor. Did you do that? Did you? Yes, I did that, and I'm real sorry. I was drunk that night, and gosh, I know I shouldn't do that, and so I'm going to give Sam the $150 he wants. Well, there's a cause of action. Sam's got a cause of action, but why does the state of Idaho want to get involved in Sam's cause of action and invoke a fine or a fee here of $50 or $100? Why do they want to charge me criminally for what is obviously a civil action? If the people of the state have been damaged, then the people of the state have got to bring an action against me. If the body politic, that is the state of Idaho, has suffered a damage, then the state of Idaho has to bring a cause of action. But it's not a crime not to buy a driver's license. It's a civil matter. I didn't live up to the terms of the contract. Wait a minute. That's insane. How could I fail to live up to the terms of a contract that doesn't exist? That's like you bringing your neighbor in and charging him with $150 damage for failure to sign a contract to agree not to drive his tractor across your lawn. You see, the logic is totally lacking in such an absurd position. If you had a contract with the neighbor and he agreed not to drive the tractor across your lawn, and then he drove the tractor across your lawn, you've got a cause of action because you've suffered a damage. But if there's no contract and he doesn't drive the tractor across your lawn, there's no cause of action. You can't compel him to sign a contract. And if he drives the tractor across your lawn and causes you a damage, you've got a right to sue him at the common law because you've got a substantive damage. You don't need any contract with somebody to agree not to cause you a damage. Once he's caused the damage, you've got a cause of action to restore, to replace, to make payment, to compensate you for that damage. And so here we've got the state of Idaho claiming they've been damaged because I refused or didn't or omitted to enter into a contract with them. And then they wanted to charge me $7 to enter into the contract. What happens if you go into a store and you say, I want to buy that washer and dryer? And the fellow says, okay, here's the contract. Now, in order to get the contract, we're going to charge you $10. That's just for the privilege of signing the contract. Do you think that a store could stay in business very long if they charged admission to get into the store? If they charged you to sign the contract? No, the contract is something that comes because of the sale that now requires some specific performance. Well, what specific performance am I obligated to do to drive on my road out there? That's a public right-of-way. I'm not going down here and sign a contract with my government. But what have they done? They've passed a law that requires you to sign this contract. Can they do that? They can do that to Garrett Truck Lines, because Garrett Truck Lines is using that road for trade, commerce, business, and industry. And because of that privilege of using our road to make a profit, we have authorized our legislature to charge them a fee. Their drivers must adhere to regulations and rules. That's where the driver's license, registration, and proof of insurance really attach. They don't attach to normal, natural citizens with inalienable rights unless that person, for some reason, wants it to attach. So when we're talking about a plea, how could I possibly walk into a court and enter a plea of guilty or not guilty to an event that never occurred? You're asking me to walk in and plead not guilty to failure to sign a contract with my neighbor in which I would agree not to drive across his lawn and make ruts. And I'm sitting here saying, wait a minute. I'm not going to go over and sign a contract and spend money with my neighbor to sign a contract to do something that I'm not going to do anyway. I'm not going to use that road out there for trade, commerce, business, or industry. So I don't need to go down and get licensed to not do something that I'm not going to do, or to do something that I'm not going to do. Since I'm not going to haul anything on the road for profit or gain, I don't want a license. Does that make sense? Well, let's think about it for a moment. Since I cannot, this is at the bottom of page 1, it says, since I cannot understand any charges, bearing no cause of action, I cannot enter a plea to the court. But I recognize the court, acting in summary proceedings, will enter a not guilty plea in my behalf, and thereby enter, and I hereby enter, my objection to the entering of said plea by the court. Well, now, why would I want to enter that? I didn't do it, so why not let the court enter a not guilty plea? Well, take a look in your Bouvier Law Dictionary at plea and pleadings. When that court enters a not guilty plea, it has assumed jurisdiction in this matter. Yeah, that's right. That court, this administrative law court, has assumed jurisdiction because you failed to object. Failure to object is fatal. Mr. Jones, I see that you're wearing a blue tie in the courtroom today. Total silence. The record is turning around. When the case goes to the appeals court and they're reading the paper and it says, Mr. Jones, I see that you're wearing a blue tie today. Well, then, the man reading the paper has no alternative but to believe that Mr. Jones was wearing a blue tie. Mr. Jones did not say, I object, Your Honor. The tie that I am wearing is red. Well, now, if Mr. Jones were to object, and you're reading the paper, it says, I see, Mr. Jones, that you're wearing a blue tie today. I object, Your Honor. I'm wearing a red tie today. Well, now what is the appeals court going to decide? Are they going to decide that it was blue or red? They cannot decide because it's a contested issue of fact. The court has to say, well, without some evidence, without some testimony, we cannot determine whether the tie was red or blue. So therefore, as a matter of law, we must conclude that the defendant's statement in this case is true because the government has not proven that the tie is blue beyond a reasonable doubt. You see how you win that one? reasonable doubt in a criminal matter as a matter of law must be established by the government. So if you've got a plea entered of not guilty, the court then will assume that it has jurisdiction. You didn't object, and therefore you then are a person required to have a driver's license, because this is the court that tries cases of persons who have driver's licenses. This is that administrative law court that decides these matters on the road. Well, now, if you're a person who doesn't have a driver's license, you cannot be tried in this court. You've got to be tried in the district court, the court of original jurisdiction for natural persons who are citizens at the common law. And so you're going to say, well, I don't have a driver's license. This court is not a court of competent jurisdiction, and therefore this case must be dismissed. And the prosecutor must then bring this court in a cause of action, state his cause of action, and tell the court of competent jurisdiction that there is a cause of action before the bar. And since the prosecutor can't do that, since the prosecutor cannot bring an action in the district court and claim that you failed to sign a contract, he doesn't have a case. The prosecutor only has a case with persons who have driver's licenses, in the same way that the tax court only has jurisdiction over taxpayers. The tax court has no jurisdiction over a non-taxpayer, and so you've got to make the assertion or the objection, I'm not a taxpayer. And that's why this tax court has no jurisdiction. So they're going to enter a plea of not guilty for you, and you've got to object to that plea. I again demand all of my common law rights. I'm on page 2. Right at the top of the page, I demand all of my common law rights. And if this court proceeds to trial over my objections, then I demand a trial by jury at law with a 12-man jury of my peers. Now, that's a mouthful. You have to, according to our Supreme Court, go through the lower court procedure. In other words, you come into the traffic court as a citizen at law, and you raise all of your constitutional objections just like you would if you were in a court of original jurisdiction. You demand of that administrator that he produce a 12-man jury. And he's going to tell you, well, Mr. Gordon, that's ridiculous. Why, the Constitution of the state of Idaho provides for a 6-man jury under blah, 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 and therefore this court is bound by the state constitution. Well, of course the court is bound by the state constitution, which is proof positive that the court can't try you in this forum because you're a citizen at the common law without a driver's license, brought into the tax court, and you're not a taxpayer. You're brought into the traffic court, and you're not a licensed driver. You're brought into a court here into the patent court, let's say, for armed robbery. This court can't hear cases at law concerning crimes. This is a patent court. See your argument? So you have to come in, make your challenge to jurisdiction, and then demand your right to be taken to the court of proper jurisdiction. And he'll deny that, and that's your winning argument, because now on appeal, you're going to show in the trial that you were a person drugged through this administrative court against your will over your objection. They didn't have jurisdiction, and therefore the higher court will reverse the lower court's decision. Bail. This free and natural person qualifies for release. O.R. Now that O.R. you see there isn't or, that's on my own recognizance. So put a couple of little periods there. Under the provisions of Rule 46, and therefore should not be required to post bail unless the plaintiff, that's the government, can show just cause that this person will not appear. Now the only reason for bail, my friend, is that the court doesn't know if you're going to come back or not. Now my record's impeccable. I've never missed a hearing. I've never missed a court appearance. If you've missed some court appearances, you're going to have some problem getting out or without posting bail. Remember, bail has one function and one function only, and that's to guarantee your appearance. And if you can guarantee your appearance, then there's no bail required. So check your state's criminal rules and find out what the rule is in your state. That's a judicial determination. That's not legislative or executive. The courts will decide who pays bail and how much, and they'll do it by their own rules under the doctrine of the separation of powers. We'll talk about bail in a little more detail after we watch the next arraignment. Now, let the record show that I have and will never voluntarily acquiesce to the jurisdiction of this court. As mentioned before, no cause of action has been asserted, and therefore no jurisdiction exists before the court. The accused has consistently and continually objected to the jurisdiction of the court, as jurisdiction has never been asserted and proven, and once jurisdiction has been challenged, it must be proven. How many people did you witness earlier demand that jurisdiction be proven? You see, they came in and pled guilty, or they came in and pled not guilty. They came in and acquiesced to the jurisdiction of the court. There's a right that's waived. There's a right that need not be asserted and proven by the government, because you came in and voluntarily said, in effect, yes, I understand the charges, I understand the willfulness of my actions, and I understand that this is the forum, this is the format, this is the place to come for me to be heard. And it cannot be summarily ruled upon and cannot be obtained by estoppel. You can't just come in here and grab, demand, and assert jurisdiction or presume jurisdiction, Judge. The only reason this person enters the court and motions the court is because the court and its agents, the marshals, have established a record of incarcerating accused persons, enforcing jurisdiction through the imposing of bails, as it is recognized by the court that few persons can afford to spend the 4 months in jail between arraignment and the trial date just to keep denying the court's jurisdiction. Take a look at bail in Bouvier's Law Dictionary. Take a look at the word jurisdiction and arraignment, and you'll find that when you pay bail, you grant that court jurisdiction. I never pay bail, or very rarely. If they try to charge you bail, you need to make the objection. I do not grant this court jurisdiction by the payment of this bail, and that this is an extortion of ransom from me, that I must ransom my freedom from you or you will put me in jail. It won't take very long until those lower courts wake up to the Supreme Court's decisions and rulings. Argersinger versus Hamlin, take a look at that one. You can't put a man in jail without counsel. And here you are at arraignment without counsel in a traffic court, and here's a fellow who's going to demand that you post or pay some bail. And you've got to call him on that. Are you trying to gain jurisdiction over me by imposing bail, Your Honor? This amounts to the obtaining of jurisdiction by compulsion and is null and void. Although the accused denies the court jurisdiction, the accused readily recognizes certain powers of the court that this court can and does exercise whether jurisdiction is valid or not. You know, they may not have the jurisdiction. They may just like a salesman say, did you want red or green? Now come now, man, I'm a busy man. Well, green. Well, as soon as he says green, you just closed the sale, haven't you? And so here he is saying, you know, did you want to post the bail or did you want to go to jail? Oh, well, I want to pay the bail, Your Honor. That's the old salesman's ruse. Did you want green or red? And as soon as you say red, the sale's closed. Now it's just a matter, how did you want to pay that? Did you want to pay that by check or cash? Could we make payments? Oh, you want the easy payment plan. Here's our contract right here. Sign on the bottom line. Take this out to the marshal and enter into a payment agreement. Talk about salesmanship. Let me tell you, these prosecutors and judges are master salesmen. All you're talking about here in the courtroom is the hype. You find it in the carnivals every day, and the courtroom is nothing but a carnival. So once you understand that you're a person who has rights and that you don't have to go into that carnival atmosphere and give up those rights, and that if this carny here grabs you and takes your money, that you now have a cause of action. You can take him to court, and you can prosecute him criminally and civilly for violation of your civil and constitutional rights. But you can't do that unless you know you've got those rights, can you? Going on then, the accused also recognizes that the court will proceed regardless of proper jurisdiction, and therefore the accused has no other alternative but to defend against the loss of life, liberty, and property. You ever seen an encyclopedia salesman come up to the door? Doesn't he stick his foot in the door and tell you he's not taking it out until you let him in? And so the judge, he just sits here and says, well, I'm going to assert or presume jurisdiction in this case, and I'm not letting you out. He's just sticking his foot in the door. You know what I do to a judge that puts his foot in the door? I open it up about 3 feet and slam it. That's the way to take care of that. About the second or third time that judge gets his foot caught in the door, he'll recognize a free man. And pretty soon you'll find that the jailers don't like you in jail and the policemen don't like to give you tickets anymore. There'll be a real revolution in your county wherever you are. It'll take a jail stint or two, and it'll take some practice in the courtroom. But it doesn't take them long. I've done it here in our county for about 8 months, and I noticed that in 8 months we've got some real changes here. Going on then at the bottom of page 2, if the plaintiff and the court insists upon trying this free and natural person when no crime has been committed. How do you like that? Here they are bringing you into this pretended jurisdiction on a pretended charge, and you're telling him there hasn't even been a crime. We've got an omission. We don't have a crime. Take a look at the word crime, and you'll find that it requires intent and an act. Now, what's an omission? It's the opposite of an act. Take a look at the word omission. The very definitions of these words will show that you're not guilty of committing any act or crime. And here they've brought you in here, and you're saying to them, no crime has been committed, and jurisdiction has not been asserted and proven. You've hauled me into this tax court, and you haven't even shown I'm a taxpayer. And then the plaintiff and the court needs to be advised that there may be a violation of this person's rights, and proceedings may be without proper jurisdiction in this specific case. Never challenge the statute. Never challenge the court. In this case, with this person, I don't know about those other people over there. They may all have driver's licenses. You may have contracts with them. They may be obligated to some specific performance. I can't speak for these other people. I can only speak for myself, Your Honor, and I'm not one of those people. Therefore, some municipality or other agent of government may be liable for damages to the accused because of constitutional violations of this free and natural person's rights. C. Owens versus City of Independence, 1980. That's a civil rights case just decided recently. Let these people know that when they violate your rights, that there are remedies that you may appeal to. Now, I've signed this one, dated it, and I'm going to show you 2 ways to drop paper on the court. So let's take a look at the arraignment and plea of the defendant.
Let's see, the next case we have here is one Mr. George K. Gordon. Is Mr. Gordon in the courtroom?
Yes, Your Honor, I'm here.
Mr. Gordon, we have here 3 uniform citations. One of them charges you with failure to carry a certificate of insurance on your vehicle. One charges you with failure to register a vehicle. And the third one charges you with failure to exhibit a driver's license upon request. Do you understand these charges, Mr. Gordon?
Well, Your Honor, before we get into the merits of the arraignment, I think we have some administrative and procedural matters that we should take up prior to moving forward.
Proceed, Mr. Gordon.
I think that the administrative and procedural matters that need to be talked about here are the jurisdiction of the court, the action at bar, and whether or not we have a prosecuting attorney or a public prosecutor in this case. Now, specifically, I'd like to make a statement for the record that I don't believe we're in a court of competent jurisdiction here this morning, Your Honor, or this afternoon. And the reason that I don't believe we're in a court of competent jurisdiction is that I perceive that this court is a equity jurisdiction pursuant to Title 49 of the Idaho Code, which would require voluntary compliance into a regulated enterprise. Now, I've stipulated to the officer at the scene of this alleged crime that I am not a licensed driver and that I don't have a registered car and that the automobile in question is not insured. And
Am I to assume then, Mr. Gordon, that you're pleading guilty to all these three charges?
Absolutely not, Your Honor. I'm stipulating the facts. And in stipulating the facts, that can no more be construed as a guilty plea than my statement that I have not signed up for the draft, Your Honor, and that I have not registered as a resident alien.
Mr. Gordon, I think we're straying here. What are the administrative and procedural matters you want to bring up?
Well, I was talking about the administrative matters when you interrupted me, and now I've lost my train of thought, Your Honor. Now, where were we?
Well, then, Mr. Gordon, let's proceed.
I object, Your Honor, because it's not possible for the defendant to proceed until the court is fully appraised of the administrative and procedural matters pursuant to jurisdiction.
Well, then, let's get them on the record, Mr. Gordon.
Thank
we don't
you,
have
Your
all day here.
I'll get right to it, Your Honor. Let's see now. I would appreciate it, Your Honor, if the court doesn't interrupt me while I'm making my presentation.
Well, just stay on the point, Mr. Gordon. We'll not interrupt you as long as you proceed on point.
Oh, okay. Well, let's see. I think we were talking about jurisdiction, weren't we? Yes. I believe I told the officer plainly at the alleged scene of the crime that I am not a person who is required to have a driver's license or register his car because I am not engaged in interstate commerce pursuant to Article 1, Section 8 of the Federal Constitution, that I'm driving as a matter of right, which is an inalienable right to liberty under our Federal Constitution, and that being the case, stipulated, too, that there was no cause of action and the officer wouldn't listen and wrote me these tickets, and if you'll notice, they're signed under threat, duress, and coercion. And therefore, I'm making a special appearance here. I am here under threat, duress, and coercion. I am not volunteering to come into this courtroom. And the reason that I'm standing here today is because I'm in fear that my liberty will be taken from me if I don't appear here.
Mr. Gordon, it appears to me you're rambling. Let me point out to you that Idaho Code 49317 requires that every person who drives a vehicle, a motor vehicle on the highways of Idaho has to have a driver's license. Now, you are driving a motor vehicle on the highways of the state of Idaho, so a driver's license for you is essential. 49-107 requires that your vehicle be registered. All vehicles. 49245 requires that you have insurance on your vehicle. Now, the law says every person. You are a person, aren't you, Mr. Gordon?
Are you looking for an admission or a confession here, Your Honor?
Yes, I am. I'm looking for you to admit that you're a person.
Well, I'm not here to make admissions and confessions. And you're trying to gain a confession by quoting out of context a legal axiom. And I'm not going to make any admissions or confessions, and I don't want to claim to be a person who is required under Title 49 to have a driver's license, register his car any more than I'm going to make the admission that I'm a person who's required to register as an alien.
Well, Mr. Gordon, I'm not going to quibble with you on these matters. You do not have a driver's license. You were driving. The officer here has signed the complaint to that effect. So we're going to assume jurisdiction, and what I want to know now is, do you understand the charges here?
Absolutely not. And we're moving ahead, and we have not covered the administrative matters that are necessary and imperative at this hearing. Now, this hearing is designed to determine whether or not we move forward to trial. I do not want my government to compel me into expensive litigation that requires hundreds, if not thousands of dollars to defend.
Mr. Gordon, that's not an issue here. The issue here is whether or not we shall bind you forth for trial on these charges.
I object to that. This is absolutely a matter that's necessary and imperative to be determined. If the court doesn't have jurisdiction...
If you have a question to determine, please state it succinctly and shortly, and the court will rule on it, and then we can proceed.
Where does this court get jurisdiction over a free man?
This court has jurisdiction over all misdemeanors. Idaho Code.
This misdemeanor is pursuant to Title 49. Are all persons in the state of Idaho, without exception, absolutely required to have a driver's license?
The code says every person, and I assume it means what it says. This court is bound by the code and the Constitution, and we go by what it says, so let's proceed from there.
Does the court then assume, or does it know whether or not all persons means every person?
The court is only going by the law. It says every person.
Your Honor, I demand that you give me a judicial determination on the subject of all persons and every person.
Every person means all persons. What's your next question?
All right. Now, there's a judicial determination that this court then must be presuming jurisdiction because I'm a person.
That's correct.
Does this court also presume that all persons must sign up as aliens?
That's not the question at hand here.
Well, it most certainly is.
Well, Mr. Gordon, I'm going to hold you in contempt if you don't restrain yourself.
Let me see if I understand the court's position. Are you going to do something bad, wicked, terrible, and awful to me if I come in here and demand my rights at all times?
I'm not going to do anything bad, wicked, and awful to you if you come into court and follow the procedures.
I am following the procedures, Your Honor, and I refer you to the Idaho Rules of Criminal Procedure. And in this matter, I have a right to have determined and judicial determination made of the administrative and procedural matters.
Mr. Gordon, all you have to do is bring up the administrative and procedural matters, and this court will rule on them. Please do so.
Okay. Administrative and procedural matter 1. This court has no jurisdiction in this matter.
Mr. Gordon, this court is assuming jurisdiction, and that question is settled. What's your next immediate matter to bring up?
Who is the party of interest in this action, Your Honor? Because as I see this complaint, it says the state of Idaho. And I don't see the state of Idaho represented here today. And I can't defend the case against...
This isn't the trial, Mr. Gordon. This is an arraignment.
I don't want to go to trial.
Then don't commit the crime.
I haven't committed any crime.
The police officer here has charged with you with crimes, and he has signed his name under oath. So let's not argue that point further.
Well, then we're going to proceed with the state of Idaho as the party complaining in this action.
Exactly.
There's a loss. Where is the corpus delicti?
Mr. Gordon, you have been charged with a violation of the Idaho statutes. And the Idaho statutes apply to every person, so that is all we have to go on here. And that is sufficient for this court.
You're going to charge me with these statutes.
Exactly.
Okay, that's like charging me then with failing to sign up for the draft. I'm over 18 and I admit that. But I contend that I am not a person required to sign up for the draft. And the subject matter here is, am I a person who is required to have a driver's license? And I'm contending that I'm not.
Mr. Gordon, you can bring those matters up at the trial. The statutes are very clear, and it is my understanding now that you do understand the charges against you. And I'm going to so rule, and we're going to go forward, and I'm going to ask you, how do you plead to these charges?
It's impossible to plead to these charges. There's no cause of action, so therefore I'll stay on mute.
Then this court is going to enter a plea of not guilty on your behalf, and we're going to enter for trial. Do you want a jury trial or do you want a court trial, Mr. Gordon?
Well, if the court is going to compel me forward against my will and over my objection without jurisdiction, then I demand a common law trial with a common law jury of my peers.
Then this case will be set for trial on July 15th, and at this courthouse. We're going to set the trial for 1:30 in the afternoon, and I guess that's all we need.
Well, there's one more thing I'd like to mention, Your Honor. Now, is this court going to require any bail or any bonds?
Yes, we have a $150 bail that you will have to pay, and if you're going to ask for a jury trial, and you can pay that with the clerk as you leave.
Okay, I thought that was the usual procedure, and I want to object to that, Your Honor, as a violation of due process and of the rules of criminal procedure under Rule 46. Now, I qualify to be released OR, and I demand that right. I have never missed a court appearance, and the only purpose of bail is to secure the attendance of the defendant at the trial.
Well, Mr. Gordon, there are several requirements before you can be released OR. Are you currently employed?
Yes.
Who is your employer?
I'm self-employed. I'm a teacher.
Self-employed. You have a family?
Yes.
You own a house?
No.
You don't own a house?
No.
You have no ties to hold you here in this location?
Yes, I do.
How long have you lived in your current residence?
3 years.
3 years. And where did you live before you lived in your current residence?
Boise, Idaho.
See, character and reputation. Your reputation, Mr. Gordon, this court is aware of the fact that you've been in court a great deal lately and even been in jail several times. That is not conducive to releasing a person on his own recognizance.
I've never been convicted of a crime, Your Honor. I've been in the court 33 times in 5 years. In each and every one of those cases, I have successfully defended. And I have never missed an appearance.
Well, this court then will release you on your own recognizance. It appears that you will appear.
Yes, Your Honor. I look forward to handling this case. There was one last thing. In setting this trial, you said July the 15th. Let me get that down for the time and place set certain.
It'll be in this courtroom July 15th at 1:30 in the afternoon.
1:30? I'd like to address a number of issues by motion, Your Honor. Would you set a motion hearing prior to trial?
You file a request for a motion hearing, and we'll set a time for it.
Okay, motion hearing. I'll also need an evidentiary exclusionary hearing, Your Honor, so would you schedule that hearing?
Well, you file your proper papers, Mr. Gordon, and we'll take them under consideration and set the proper time for the hearings.
All right, Your Honor. Let me see. Have we covered everything here today? I've objected to your entering a plea. I've demanded all of my rights at all times and never waived them. I've challenged the jurisdiction of the court and made a special appearance, and I've refused to pay or post bond. I think, Your Honor, with that, we'll be ready for the first motion here.
Very good, Mr. Gordon.
Thank you, Your Honor.
Your objections are all noted in the next case.